Good morning. Welcome to the First Committee of Families and Children of the 2026 regular session. I hereby call this meeting to order. As a reminder, please silence all cell phones so they don't become a distraction. Do any members have any guests they'd like to introduce? Seeing none, DJ, please call the roll.
Representative Bojanowski.
Here.
Representative Callaway. Representative Kleins.
Here.
Representative Dietz.
Here.
Representative Doan.
Present.
Representative Duvall.
Here.
Representative Elliott. Representative Holloway.
Here.
Representative Mosier.
Here.
Representative Pollock.
Present.
Representative Rayburn.
Here.
Representative Riley. Representative Rorks.
Here.
Representative Stalker.
Present.
Vice Chair Wilson.
Here.
Chair Heverin.
Here. As a reminder, every meeting I like to share the number of children that are in out of home care and foster care, and so we have 8,699 today. All right, the first bill we'll hear today is House Bill 109. Representative Dietz, if you could make your way to the testimony table. Please introduce yourself for the record when you get situated, and then you can begin.
Good morning, Madam Chair and members of the committee. I do have a cold, and I do have a cough drop in my mouth, so I apologize. Thank you for allowing me to present House Bill 109. I'm going to tell you first what the bill does. In my mind, it's a fairly simple bill. It amends KRS 403.044, which currently requires a waiting period for families of 60 days. If a husband and wife are getting a divorce and they have minor children, they have to wait 60 days from the date that the response is filed in order for that divorce to be finalized. There is no waiting period if you don't have minor children. So if Madam Chair will allow me to maybe explain the process a little bit. Our courts our family courts are set up in a way that we have to follow the same rules that we do in a traditional litigation case. So if you're talking about medical malpractice, if you're talking about having a swimming pool installed incorrectly, you have to initiate that proceeding with a complaint, but we call it a petition, and it has all statistical information in it that is set by statute. The next step is you have to have somebody served. And I would say, and I'm looking at least one of my colleagues in Northern Kentucky, I think as family law practitioners, we make every effort not to have somebody served at home in front of kids and not in the workplace. That's terrible. It's not the best way to start that process. But a response has to be filed, and you have to serve the individual because we have to follow the civil rules. And we can't get around that. So once that response is filed, that 60-day waiting period starts. I don't know the legislative intent from this from over 30 years ago. I know there's many states that have a longer period in order to enter the decree. But there's a process that goes on between the response being entered and a decree being entered. Our family courts have gone through a lot of change. Our court system has. I've been practicing 32 years, and when I started practicing, we didn't have family courts in Kentucky. We were fortunate that in Boone County, we had one of the pilot projects, and then Kentucky went to the family court system. So I practiced when we still had circuit court judges and we had district court judges. We didn't have mediation when I started practicing. I remember going to my employer saying, "Can I take this training?" And she said, "Why would we do that when we have judges that make decisions?" So we didn't have alternative dispute resolution. We now have mediation. We also have, and this legislative body passed 2 years ago, my bill on collaborative family law. And that's a negotiation model where the parties work ahead of time before they file their petition to try to resolve all of their issues, including custody and parenting time and their asset division. Do not think that this is attorneys knocking on doors asking people to get divorced, because that's not what we do. It is a legal process, no different than how you go through a medical malpractice case. We have to follow the same civil rules. And in fact, we have more rules as family law practitioners because we have family court rules of practice and procedure that mandate that we do financial disclosure affidavits. And I believe the wording is shall. So if you don't choose collaborative family law and you choose a traditional litigation approach, you have to file, and it's an AOC 238 form. You have to. It says shall. You can waive the final. So what this bill does is it allows people that have chosen to go through mediation ahead of filing their petition or chosen to do the collaborative family law process the opportunity at the end when they file everything to go ahead and have their decree entered. And why is this important? Because I think that they've made the right choice. When my clients come in to see me, I can tell you that I always offer them what all the options are. And we talk about litigation and why in the world would you want a man or a woman sitting in a black robe making decisions for your family when you have the opportunity to sit down and come up with your own parenting schedule, your own holiday schedule. Keep those traditions that are important for your kids. This is not trying to make divorce easier. And I would say to you, there's not one person that's come through my door or that I've ever seen in the courtroom that would say divorce is easy. It's one of the hardest things that they can do. And when people say what's so great about collaborative or mediation, going to court is terrible. You are forced into that adversarial process where you have to say terrible things about the other parent in order to win. And the worst telephone calls I get from a new client are the ones that say, how many cases have you won? Because in my career, I've lost every single case I have because they're losing half their assets. They're losing half the time with their kids. They're losing. So I've not won any cases as an attorney. So those are not the clients I want. I want the clients that are going to sit down and do something that's thoughtful for their family unit. And maybe they learn communication skills during this process. They learn how to talk to each other. They learn how to co-parent at a much higher level. So that's what I'm proposing today. I have really limited this. I have filed this every year that I've been here. The first year was just to remove the 60-day waiting period. And I've limited this to people that have put in the hard work ahead of time. And I don't want them to be punished. And I will say, and this gets really into the weeds of what we do as family law practitioners with assets. When you do a property or custody agreement, which is that's your contract that you enter into that is ultimately included into the decree that makes it enforceable as a court order, but there are things that are tied to that decree. And one of the big ones is a division of retirement accounts. I've recently had a case, and we do this a lot. The IRS tells us how we divide retirement accounts, and we have to do it by a qualified domestic relations order. And that's done after the decree goes on. So I've had clients come in and they have substantial amount of debt, and they may not have the cash to pay that off. And we want everybody to be able to walk out debt-free, reduce any ties to each other so they're not running back to court. So one of the things we do is we can award the other party more of that retirement account for any tax implications they're going to have by taking a withdrawal, and pay off their debt. So if we include that in the property settlement agreement and they've worked on this for a year, then they have to wait another 60 days so that we can do the quadro. And those quadros aren't done overnight. Those can take 4, 5, 6 months for those, depending on the company, to get those done. So there's a delay in dividing the assets sometimes if after they've worked on this for a year and a half. So all I'm proposing is that if they've put in the hard work ahead of time and they've chosen to keep their divorce private, they've chosen to stay out of court, and they decided that they were better equipped to make decisions for their kids and come up with a thoughtful parenting plan, that at the end they be allowed to put their decree on and go ahead and get divorced. And that's what this does. It does not get around the 60-day period if you're in that litigation model, which is just filing your petition and then following everything through the court. And my last anecdote would be that we had a judge who's now retired. And the moment you filed a petition, he put you on their case management conference. You were on motion docket right away. So the family, regardless of whether they wanted to stay out of court or not, they were forced then to be on motion docket.
I've got a motion and a second. Do you want to continue what you were saying, or?
Nope, I'm good.
Okay. I do have someone signed up to speak against the bill. If you will stay at the table,
Yes.
and Mr. David Walls from the Family Foundation, if you will come up. Please identify yourself for the record, and then you can speak.
Absolutely. David Walls, Executive Director of the Family Foundation. Good morning, Chair Heverin and members of the committee. Again, I'm David Walls, and if you're not familiar with the Family Foundation, we're a Christian public policy organization that stands for Kentucky families and the biblical values that make them strong. Thank you for the opportunity to express our concerns about House Bill 109 this morning. The family and marriages and our families that are built upon those marriages are the most foundational social unit on which our society is built. We believe our state policy should reflect this fact, and unfortunately, we believe by making divorce easier for parents with children, HB 109 would harm marriages, families, and children. I will say I'm incredibly grateful for the time and the very fruitful and productive conversation I had with Representative Dietz yesterday. She was very kind with her time, and I very much understand her perspective. However, ultimately, this bill would make it easier and quicker for parents with children to get divorced by eliminating a 60-day waiting period when children are involved in certain circumstances. We believe that this is the wrong direction for state policy to be headed. Kentucky, with only a 60-day waiting period for divorces with children, already has amongst the most lenient and shortest in the nation of states that do have waiting periods. Many states have considerably longer waiting periods, and some research has shown that states with longer waiting periods have lower divorce rates. Waiting periods can be beneficial for several reasons. They encourage reconciliations, they affirm the importance of the marriage commitment, and they can be fairer to the spouse that may be left. As Dr. William Daughtry, a well-respected professor, researcher, and family therapist, has written with the Institute for Family Studies, 30 years of research has shown that only infrequently do both parties want the divorce. Generally, one spouse is pushing for the breakup while the other wants to stay married. Quick divorce on demand favors the one who wants out, leaving little opportunity for the other spouse to make adjustments to see if the marriage can be salvaged. Dr. Daughtry goes on to note in his vast research that the assumption that people have abandoned hope in their marriage and just want to get the divorce over quickly is not generally accurate, and that a substantial number of parents in the divorce process believe that restoring their marriage is still possible. Further, the numerous harms of divorce on children are absolutely devastating. Negative impacts on children's learning capacity, their education, increases in drug and alcohol abuse, physical violence, increases in behavioral, emotional, psychiatric risks, including suicide, and even an astounding decrease in life expectancy. We also know, obviously, divorce creates devastating emotional and financial problems for both husband and wife, mother and father. And on the fiscal impact, it is estimated that family fragmentation costs the government and taxpayers very conservatively $112 billion in divorce and single-parent related social programs. That's over $1 trillion every decade. At the state level, family fragmentation is estimated to cost the Commonwealth of Kentucky at least $375 million every year. Given the fiscal and moral situation of our nation and state, it is certainly time that we take a look at meaningful divorce reform that seeks to strengthen marriages and families while keeping the impact on children central to the conversation. Kentucky and the entire nation's embrace of unilateral no-fault divorce has weakened the institution of marriage with disastrous fiscal, societal, and human consequences. The link between the emergence of no-fault divorce and the rapid rise in the nation's divorce rate is indisputable. Replacing the culture of divorce in America with a culture of strong and healthy marriages will require, no doubt, a great deal of innovation, education, and hard work. Every effort must be made to encourage couples to save troubled marriages. A part of that conversation should include looking to increase Kentucky's waiting period for divorce, not eliminating it. In closing, I would like to share about a very important initiative called Greater Than that the Family Foundation has just joined with state and national groups from across the country that actually just launched last week. Greater Than is a coalition of parents, students, researchers, think tanks, influencers, and citizens who are willing to state the self-evident but very costly truth. Children need, deserve, and have a right to their mother and father. Marriage is and always has been the most effective tool to secure that right. We believe in justice and in protecting the vulnerable, but we simply recognize that the truly vulnerable are children, those who've been harmed when their rights are sacrificed in service of adult desires. We are willing to fight for them because they cannot fight for themselves. Restoring marriage to a child-protecting institution must be of paramount importance. In a world that routinely asks children to bear the cost of adult choices, we must have the audacity to insist on the opposite. Adults should sacrifice in matters of marriage and family, not children. We are committed to restoring laws and policies that place responsibility where it belongs, on the shoulders of adults, not on the backs of children. For these reasons, we respectfully ask this committee and your fellow members of the General Assembly to oppose House Bill 109. We would certainly welcome the opportunity to be a resource in addressing the need for divorce reform in Kentucky, ultimately with the hope of strengthening marriage and families while ensuring children are protected. Thank you again for the opportunity to speak.
Thank you. Do members have any questions for Mr. Walls or Representative? First on my list is Representative Bojanowski.
All right, I wasn't going to speak on this bill because I didn't find anything that Representative Dietz said mandating that I say something. But Mr. Walls, I am personally offended by your statement. I've gotten divorced. It was a horrific time in my life. But by the time that I was at the point where I decided I need to get a divorce, it was better for my children to have that marriage dissolved and as quickly as possible than it would have been to stay in that marriage. And I'm serious, I'm just seething right now for you to say that this bill makes divorce easier and to basically litigate the whole function of divorce in our society when all Rep. Dietz was doing is saying that after a couple goes through mediation, which is not an easy process and it is not a quick process, once mediation is done and they've come to an agreement, that we don't have to wait another 60 days for the divorce to be final. I'm not going to say much more, but I'm just very offended by your statement, by your tone, by the thought that I may have done a misservice to my children, which is 100% untrue.
I'll just, okay.
Thank you, Representative Bojanowski, for your vulnerability. Representative Elliott.
Thank you. Thank you, Madam Chairman. Good morning. Representative Dietz, I know in my family court circuit, the judge actually has a rule that says that he can require married couples who have children to actually go through parental education classes before he will enter a decree. So I think in some circuits there continues to be safeguards that I think Mr. Walls is advocating for. But I say that to lead to a question. What is the average time typically that you find with your clients when they are going through the collaborative process or the mediation process between when they come to you to file and when it's over? Can you kind of estimate how long that takes typically?
I can, and I'll start by saying in Northern Kentucky, we've been doing collaborative family law. I think 26 years is when we formed the group. There are also groups in Bowling Green. I think Lexington and Louisville still have active groups. So with that, I will say it usually initiates when the client comes into your office. And I think as a practitioner, you offer them options. And selfishly, I always tell them how bad litigation is and try to encourage mediation or collaborative. So then they have to find an attorney that has been trained collaboratively. And if they don't, that's for their spouse. And in Northern Kentucky, at least, we have a website they can go to that we've started. If they don't hire an attorney that's been collaboratively trained, then we kind of shift into that mediation. So to get on my calendar, I mean, it's probably at least 2 to 3 weeks out. And then to get on another attorney's calendar, if they've got appointments in court, that could be 2 to 3 weeks out. And then you have your first meeting. And in collaborative, typically best practice is to meet every 2 to 3 weeks. There's the gathering of information. I mean, you don't sit down that day without having information. I think that would be malpractice. We've got to get retirement account statements and bank statements and all those things. So on average, I would say a collaborative case is probably about 6 months. And they're doing that work on the front end. I've had some that take 1.5 years. If it's a high asset case and not complicated, so if you need a business evaluation, if you need commercial real estate, if you need a real estate appraisal, those all take time. A real estate appraisal, I think in Northern Kentucky is probably at least 30 to 45 days out. Commercial real estate, a little bit more. A business evaluation, I've got one that's over 1 year old right now because we're still trying to get all the information for the evaluator. So I would say they're physically separated, and I want to talk about that just a little bit about what physical separation means, but they're physically separated by the time they're finished, probably 9 months to 1 year before that. And I'm, as Rep. Elliott, maybe Rep. Doan realize, our statute says that you're separated for 60 days. And I talked to Representative Doan yesterday a little bit about what we interpret that to mean as practitioners, and that's a physical separation. That means they haven't had intercourse in those 60 days. That means when by the time they're divorced, and the purpose, I believe the legislative intent was that we're not, and I'm going to use the word bastardizing children, because that 60 days gives them enough time to know whether or not they're pregnant when they go to court for that final hearing, so that you're not having then to go back and establish paternity after a decree is entered. So I believe that that's those 60 days is why the legislature put the 60 days in there, and it wasn't necessarily for a cooling off period. There are other states that I think when you have 6 months or 1 year of separation, that is clearly what that intent is. I will also say that by the time most people get to my office, they've tried couples therapy, individual therapy. They've talked to their priest, they've talked to their minister. And what I hope we're doing with collaborative and mediation, and I've had some that terminate. I was talking to Rep. Calloway about one case I had, and we were 4 meetings in, and they called us and said, "You all helped us so much with our finances. There's no reason for us. We've figured this out." And I agree with Mr. Walls. We talked about this yesterday, and he was able to give me some resources on financial counseling that I'll be able to share with my clients, because that is one reason people tend to, I think, get divorced. But to your point, it's at least 6 months or 1 year when they're physically separated.
Thank you.
Representative Mosher.
Thank you, Madam Chair. Thank you so much for the work that you've done on this bill. I so appreciate it. I know that you've worked on this for a long time. And just the ability to work with couples to enhance communications and put in place meaningful co-parenting is invaluable. I grew up in a divorced home, and I know how hard it is on the kids. And if that had happened, I think, I don't know what would have happened with my parents' divorce. Maybe it was inevitable, but it would have, it just would have changed the dynamics. And so I guess my question is there's not a requirement for counseling prior to the finalization of a divorce? It sounds like you answered my first question, which was, does it take longer actually to go through mediation than to go through a court process in a traditional kind of divorce? But, there's no requirement for counseling, right?
There's not. And to Representative Elliott's point, I think there's some counties, some judges that require that. I think our statute still allows, they call it a reconciliation conference that you can ask for. I've had that happen before. I've asked for that before. I will say, at least in the counties that I practice in, the judges tend to decline that unless both parties agree, because they're not going to force the parties into joint therapy or reconciliation. But there is still that part of our statute that exists that you can ask for a reconciliation conference. Whether your judge grants it or not, I think that's their discretion.
Okay. All right. Thank you.
Thank you. Seeing no further questions, we do have a motion and a second on the bill, but before I call roll call, I really want to say I feel like I really pride myself in bringing legislation in front of this committee that helps families. And being a child of divorce myself, Mr. Walls, I wanted to ask you if you were a child of divorce, but it's not my business. But I think what I want this conversation to lead to is we talk about the importance of people staying married, but we don't always talk about how it makes kids feel whenever they were the product of divorce. And I don't think I'm any less of a human because my parents were divorced, just like many members of this committee. And so when Representative Deets brought this bill to me, it seems I've had a lot of friends go through divorce recently. And it's nothing, it's something that's better. We don't live in a perfect world. The only perfect person that we knew was Jesus. And we fall short all the time. But the world is it's not black and white, it's very gray. And, I'm sitting here thinking about those that are in domestic violence and need to get away. And you don't want to create that cycle for children. You want to recognize that that's not a healthy home. And so I think it's more than just a black and white conversation. I appreciate you coming to the table to share your thoughts. I would encourage the Family Foundation. I've talked to many members of my caucus about this. I would love to change the conversation of how we help single families and how we help and lift them up and kids that come from divorce. Ultimately, it's not our fault. And I would love to see the conversation change on that. And so I do appreciate Representative Deets, you bringing this bill. I think it's really important. I've had friends that went through collaboration. It was a 1.5 year long process. And it's not easy. Divorce, none of my friends that have divorced have been like, oh, this is what I wanted to do. Like I said, life is not black and white. It's a lot of gray and in between. And so now that we have a motion and a second on the bill, I will call roll call. DJ, please call the roll.
Representative Bojanowski,
Yes.
Representative Callaway,
Yes.
Representative Kleins,
Yes.
Representative Deets,
Yes.
Representative Doan,
Yes.
Representative Duval,
Yes.
Representative Elliott, Representative Holloway,
Yes.
Representative Mosier.
Explain my vote. Madam Chair, thank you. I'm struggling with the counseling bit. I think this is so much better than the traditional route. I would just like to maybe talk to you a little more about how we strengthen the counseling. I don't know that we can require it, but I think it would be invaluable to go through the process that you're explaining. I'm going to be a no today. Just want to work with you on maybe some enhanced counseling. Thank you.
Representative Pollock,
Aye.
Representative Rayburn,
No.
Representative Riley, Representative Rourks,
May I briefly explain my vote?
Yes, ma'am.
I'm going to vote yes today, and I just want to note for the record that no-fault divorce is something that we have in place because 1 in 3 women in the Commonwealth and all over the United States experience domestic violence. And that's more apparent and timely this weekend is Shop and Share Day for domestic violence survivors. So I just want to remind everyone that I'm casting my yes vote today on this, but also want to make note that we can uplift survivors every day and help support them as they go on their journey to creating stable homes as they move forward in time. Thank you.
Representative Stalker,
May I briefly explain my vote, please?
Yes, ma'am.
I'm a yes today, and I want to just acknowledge the fact that this bill does not make it easier to get a divorce, in my opinion, at all. It simply just acknowledges that the work that the parents have already done in a responsible manner and for the benefit of their children. And I also want to say that we need to also consider the damage that is done to children when marriages become unhealthy and sometimes toxic or even dangerous to the children that are in the home. So I'm a strong yes today. Thank you.
Vice Chair Wilson, Chair Heverin.
Yes. The vote total is 13 yeas, 2 noes. It passes with favorable expression and will likely do so on the floor. Thank you, Representative Deets.
Thank you, Madam Chair, members of the committee.
We are going to stand at ease for just a moment. Our next person on the agenda is in natural resources, and Vice Chair Wilson has gone to get him so he can present on his bill. All right, Representative Johnson is here. We will continue to move forward on the agenda.
My apologies, Madam Chairwoman.
No problem. We do have a guest online, Christy Harrison, with the chief. She's the Chief Development Officer for Owensboro YMCA. Representative Johnson, if you could introduce yourself for the record, and then you can proceed.
DJ Johnson, State Representative, 13th District, Davis County. And thank you, Madam Chairwoman. And I also want to thank Christy for being online today. She is here simply to provide perspective from a daycare provider. She's very experienced in this, very knowledgeable, and if you have any real questions about daycare, she's going to be the one to answer.
We do have a committee sub. Do I have a motion on the proposed House Committee sub? We've got a motion and a second. All in favor? Yes. Representative Johnson?
I actually have to try to remember what the difference is between the original and the committee sub are. I apologize for that.
And
So what the committee sub does is basically one thing, and the original bill was going to be basically effective for all daycare centers. What the committee sub does is it provides a waiver process, a waiver request process, so that the daycare centers that are going to qualify for this new definition will have some higher criteria that they have to meet before they can qualify for the waiver.
Representative Bojanowski, it makes it for school-age children. So this only applies to child care centers that provide care for children over 5 and 6 years old. Rather than setting on the child fatality and near fatality review panel gives me a much different perspective. And so I wanted to make sure that children in daycare centers that had these new increase in square footage requirements, that they would be able to leave the building on their own should there be a fire. Thank you. Representative Johnson, you can continue.
Thank you, ma'am. House Bill 190 is designed to provide much-needed relief.
Sorry, hold on.
Oh, okay.
So we had a motion and a
that's right.
second. We've explained the committee sub. All in favor say aye. Aye. Any opposed? All right. You can proceed.
Okay. House Bill 190, as amended by the committee substitute, is designed to provide much-needed relief to Kentucky daycare providers while also ensuring the continued safety of the children for whom they care. House Bill 190, as amended by the committee sub, amends KRS 199-896 to allow licensed daycare providers who meet specific criteria to use a slightly modified standard for the square footage available when calculating how many children the provider can serve. So short answer is it's allowing a little bit more leeway on the total square footage with respect to how many children can be in a facility. The waiver process that we've mentioned requires the provider to meet certain criteria, including being in operation with no safety violations for at least 5 years and be rated as high quality in Kentucky's quality-based graduated early childhood rating systems.
Motion on the bill.
We have a motion and a second. Representative Johnson, would you like to continue with the vote, or would you like to speak a little more?
Actually, I think that covered the gist of the bill, so I'm happy.
Okay. Does anyone have any questions? Seeing none, I am going to thank Ms. Harrison for jumping on the Zoom. We appreciate you for taking the time to do it. A rule in the General Assembly is if you have a motion on the bill is to let that vote go forward so you don't lose any votes during the process. So thank you for joining us. So it sounded like I had a motion on House Bill 190 as amended by proposed House Committee Substitute 1. DJ, please call the roll.
Representative Bojanowski,
Yes.
Representative Callaway, Representative Kleins,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Duval, Representative Elliott, Representative Holloway,
Yes.
Representative Mosier,
Yes.
Representative Pollock,
Aye.
Representative Rayburn,
Pass, please.
Representative Riley, Representative Rorks,
Yes.
Representative Stalker,
Yes.
Vice Chair Wilson,
Aye.
Chair Heverin.
Yes. We also have a title amendment on House Bill 190. Do I have a motion to adopt? We've got a motion
Second.
and a second. All in favor say aye.
Aye.
Any opposed? All right, the title amendment passes. With a vote of 14-0 with one pass vote, the bill vote passes in favorable expression and should do so on the House floor.
Thank you, Madam Chairwoman. Thank you, committee members. And thank you, Christy, for being here with us this morning.
The next scheduled meeting of the House Standing Committee on Families and Children is next Thursday, February 12th in room 171.